Boy, it's a tough act to follow, the grumpy accountant. Try to be the lawyer of moderate emotion. And the first thing I will say, nothing that I'm about to say should be constituted as specific legal advice. It's for informational purposes only. 1, 2, you can't sue. So, that all being said, what am I doing here? Why do we need a lawyer? Government basically says so. You need a lawyer for real estate transactions because lawyers made rules that say you need lawyers for real estate transactions. You literally cannot transact in property. You can't close a deal without a lawyer. So sorry about that, but you're stuck with us. That being said, it's not exactly a bad thing. If you have the right lawyer, if you're working with the right person, they can take on some important roles. I'll use a sports metaphor, notwithstanding myself not being a sports guy, so if I screw up the metaphor, I apologize. But your lawyer can be a combination of a coach, sort of working you through the deal, advising you, a linebacker, sort of protecting you from people trying to take advantage of you, and a quarterback, really running the play and getting the ball over the finish line. Did I mix up? Okay. But really, the role of a lawyer in your deal, other than to finish the formal steps, we do risk analysis and comprehension, help you understand what you're really getting into when you sign a contract, and helping you with compliance, so making sure you're dotting all your I's and crossing your T's, especially where those I's and T's can get you into trouble. So the first thing I will say, the first piece of non-legal advice, just informational advice, when you are dealing in property, start by involving your lawyer. I see a lot of deals that were completed with just the buyer and seller, maybe a real estate agent, and I mean, most real estate agents are fantastic, especially when it comes to residential deals. They know their stuff. The deal that we get is solid. But on occasion, especially when dealing with commercial properties, the deals don't always come through 100% kosher. Right now, my firm is trying to untangle a very large mess wherein the buyer and seller screwed around with the title clause. Essentially, it's a property with a lot of notices and issues from the city. Maybe it's residential, maybe it's commercial. Nobody really knows. So there's a lot of sort of legal tie-ups there. And the deal, the oral deal, was here's a discount on the price in exchange for you inherit all of these issues. And because of the way the contract was drafted, which is, with all due respect to everyone involved, gibberish, now the buyer is saying, I didn't contract for that, I didn't want all of these issues. You have to deal with them before closing. So if you don't involve a lawyer at the outset, your lawyer inherits these kinds of issues that could have been settled before the deal was ever signed. That being said, I know a lot of you won't necessarily involve a lawyer or will involve a lawyer sort of right at the end. So I'm going to proceed assuming that you're not involving a lawyer 100% and give you a few tips to work through an agreement. So what is an agreement? What is an agreement of purchase and sale for property? There are 3 essential legal elements. There's an offer. So someone puts out, I want to buy this property, I want to sell this property at this price, with these conditions, with these details. There's acceptance, so someone has to accept all of the elements of the deal. As soon as you change one element, it's a new offer, it's not acceptance. And there has to be consideration flowing both ways. What's consideration? It's stuff or things or money. So a deal for a residential home for $1 million, that's got consideration in it. Why is it important to mention that there's consideration? Because once you sign that deal, and it's a whole deal, any amendments also need some kind of consideration. The government doesn't enforce. What's the point of a contract? I should back up a second. The point of a contract is to have an enforceable promise. Generally speaking, the government doesn't care to enforce your promises. If you promise your wife or your husband that you're going to take out the garbage, the government's not going to help you out if your wife or husband doesn't do that. But if there's consideration flowing, so if I offer $10 to take out your garbage and then I don't take out the garbage, you can sue. That's a contract. It doesn't necessarily have to be in writing. That being said, real estate does have to be in writing. So when you're doing a real estate deal, no oral deals, and make sure everything is in writing and has proper consideration flowing back and forth. Because a lot of the times people will amend deals after they're done, which is totally fine. You can always change the terms of a deal by mutual acceptance, but if there's no consideration, no flow through on both sides, it's not necessarily going to be an enforceable arrangement. So generally speaking, a real estate deal is going to be on the OREA, that's the Ontario Real Estate Association agreement forms. Forms 100 and 500 are the commonly used ones for residential and commercial deals. What I was saying before about the client who's experiencing issues, the main issue is because there's some very important clauses in there, specifically clauses 8 and 10 that deal with title. There are just a bunch of lines through them, and you end up with an illegible agreement, one that means something, but one that no one is sure what it means. So the biggest, if you walk away with one thing here, never, ever do that. Never screw with the OREA forms. They are, we're in a Jewish space. They're the Bible. You don't write in the Bible. You can write commentary. So one thing that people do when there are elements of the deal that aren't included in the standard form, specific conditions, and I'll get into what conditions and representations and warranties are, but when you want specific things, you attach them as a schedule to the deal. And what that does is it signals that even if there's something contradictory, because there's a standard form, but you specifically decided on things to include in the schedule as a general rule, and again, we're going back to don't take anything I say as legal advice for any specific scenario, because every situation is different. But as a general rule, a schedule overrides the standard form. So if you have specific things you want to include that aren't in the standard form, or you want to contradict something in the standard form, write that out in the schedule. So I mentioned representations, warranties. What are they? Representations and warranties are essentially everything that's important to you in a deal. If you are buying and you are in the process of drafting your deal, include everything about the property. So whether it's the number of tenants or the income of tenants or the zoning or the legal status of the property, include that as a representation or a warranty. Generally, they're grouped together. The difference is with a representation, that a breach of that. So if someone says this property has a dozen tenants, and you do your due diligence, and it turns out only 6 properties are rented, that lets you rescind the deal. It means you can get out of there, no problem. A warranty doesn't. A warranty lets you, after the fact, sue for damages. So if the seller is warranting for something about, say, the environmental status of the property, and you buy the property, and a year later it turns out that what they said wasn't quite true, that there had been contamination 10 years before that they didn't know about, they forgot to disclose, whatever, you can sue them because they warranted to you that the environmental status of the property was good. But it doesn't let you sort of flip the property back to them. That doesn't really work so well. The other element here is make sure that if there's something important to you about that property, that you're getting a representation or a warranty about it. If the vendor won't give you a representation or a warranty, it's probably not true. So if they'll say orally, they just won't put it on paper, that there's 12 tenants at the property, but don't check too hard, you can't trust that there are 12 tenants at the property. That's an issue that's going to require either killing the deal or further investigation. It's very possible that even if there aren't 12 tenants at the property, you can still sort of make something work. You can re-tenant it when the deal's closed. But if that's not included as a representation or a warranty, you could be in trouble. Some other standard representations and warranties, things you want to make sure are part of your deal. Environmental representations. Environmental liability runs with the property. It's not something that is attributable to whoever did it. So if 2 owners before there was a big oil spill, nobody really dealt with it, and it's leached into the ground, as soon as you buy the property, that's your problem. So one thing we do, especially when we know there's a big risk, is we don't, at least in my firm, we don't let clients buy property unless they're getting not just a representation or a warranty about the status, but actually an indemnity agreement. An indemnity agreement is essentially a promise from the owner or from the previous owner to step into your shoes if an issue does come up and essentially take on all of the associated costs and issues. So if the government comes at you because they've got new environmental regulations dating back 20 years, you say, indemnity agreement, talk to that guy. And maybe they will, maybe they won't, but at the end of the day, at the very least, you can claim back. And the one, are you running on time?
Yeah, no, just you.
Yeah. The one note on indemnity agreements, they're useless with corporations. Absolutely useless. Like the corporation folds the next day, you have nothing. Personal indemnities are so crucial. Conditions for a deal, these are the things that have to happen or the deal doesn't happen. There are true conditions, which are objective occurrences, things like government giving approval for something. Those things can't be waived. There are conditions that are for the benefit of either party, and those conditions can be waived. Standard conditions you need to make sure you're including. Financing condition, we have our lovely broker here who can help you find financing, but if market tanks and you aren't able to get financing for your deal, you want to make sure you can get out of it. Environmental, again, you may have questions about the environmental status. You may want to get a phase 1 and phase 2 report. Those are reports about what's going on environmentally at the property, and you may want to make the deal conditional on seeing what those say. And your due diligence condition is also important, especially if it's a tenanted property. There's going to be things like income statements that you're going to want to review that you won't have access to until the deal's signed. So you want to make your conditions, put them in, and ensure that the conditions specifically say that they can only be waived at your sole discretion, and that the deal dies if you don't explicitly waive. Why? Because you don't want them to accidentally become true conditions. Because if they become true conditions, let's say you can get financing, but it's a really crappy rate and the deal doesn't work for you then. You got financing, and if you didn't make it at your sole option, then the vendor could try to force the deal. Two other things I want to talk about, an as-is clause. Little caution here, and again, this goes back to the deal that I'm dealing with. As-is clauses generally refer to the physical condition of the property. So if you're buying a property as is, you're not going to be checking the wiring, you're not going to be checking the floors, maybe it's dilapidated, whatever. Generally that won't cover title issues. So if there are unregistered easements or registered easements that need to come off, or work orders from the city, generally speaking, an as-is clause won't cover that, and you need to make sure it's specifically mentioned if that's part of your sale or part of your purchase. The other thing I want to caution, a lot of people want to buy tenanted properties, passive income. The projections don't always reflect reality, not just because of the numbers don't work. The numbers can work, but you still have a whole bunch of obligations at law to tenants, especially residential tenants. So at least review with a lawyer or without the Residential Tenancies Act and the Ontario Human Rights Act before you even think about becoming a residential landlord. Because with those come a whole bunch of liabilities that can be financial and really can impact your bottom line with the deal. And the other element of that, if you're buying a tenanted property, even if there's just one tenant, you're going to want to include in the deal a provision that the vendor is going to get you something called a tenant estoppel. Estoppel is a fun word to say. It has a meaning, and what it means is, notwithstanding anything else, a person is estopped from enforcing a right. So when you see a lease, that isn't always everything that's in an agreement between a tenant and a landlord. Sometimes they're oral agreements, sometimes monies have been paid here, sometimes liabilities have been paid there. The importance of the tenant estoppel is that it's a signed document from a tenant saying exactly what the rent is, what the liabilities are, if the tenant's commencing any claims against the landlord, if there's an issue with the status of the tenanted property. And it creates something called privity of contract. Remember, a contract is between, you have offer, acceptance, consideration. It's between two parties. So even if I, as a buyer, and you as a seller, make a deal, the tenant isn't necessarily bound by that deal. So what you want to do is create, as a buyer, a relationship between you and the new tenant through this tenant estoppel. Title insurance, get it. Your lawyer will explain why, and buying in a corporation might be good for liability. It might not. Talk to your lawyer. Is that the wrap up?
That's great. Yeah,
Thank you.